Good morning or good afternoon. I would like to welcome everyone to today's webinar, 4-month countdown to Brexit, next step for EU nationals in the UK. So glad everyone on the line could join us today. Before we get into the main presentation, I'd like to go over a few housekeeping items first. The presentation will last for about 40 to 45 minutes. And we'll have enough time left over for a question and answer. So we encourage everyone, if you have a question, to please ask it. And you can do so using the GoToWebinar control panel that you'll see on the right-hand side of your screen. This webinar is being recorded, and we'll send you the recording and the slide deck after the presentation concludes. So please keep an eye out in your email inboxes for those links. All right, so for those that are unfamiliar with Envoy, for nearly 20 years, Envoy has been on a mission to fix the confusing, frustrating, and inefficient immigration process. Envoy combines expert legal representation with innovative technology to deliver the only platform that makes it seamless for companies to mobilize, hire, and manage their global workforce. Envoy secures work authorization in 150 plus countries, has grown 46% year to date, and works with over 1,000 customers. Envoy is particularly proud of their NPS score, which is a testament to the employee experience the company provides. All right, so now I would like to introduce, we're also joined today by Smithstone Walters, a leading UK immigration consulting firm. Established in 2001, SSW is regulated by the OISC, and they have offices in London, New York, Hong Kong, and Mumbai, providing on-ground support to individuals moving to the UK. The service offering centers on the provision of UK immigration advice and support to international firms seeking to relocate staff to the UK. Smithstone Walters manages applications, submissions for employment approval, and related entry clearance petitions. Smithstone Walters represent more than 200 public companies and 2,000 private companies across all industries, from established blue-chip multinationals to recent startup companies. All right, so now moving on to today's presenters. First, I'd like to introduce Stephanie Lewin, Head of Global Immigration at Envoy. Stephanie brings over 20 years immigration experience, and before joining Envoy, Stephanie served as Senior Counsel for Global Immigration at BAL, as well as held management positions at Crown World Mobility and Amegra Worldwide in London. Earlier in her career, Stephanie worked at the Immigration and Naturalization Service and was an in-house counsel for a Fortune 500 company. And from Smithstone Walters, I would like to welcome Anthony Hall, a Senior Account Manager, the Head of Private Client. Anthony qualified as a solicitor in 2009, gaining both UK immigration and employment law experience before joining Smithstone Walters in 2010. Initially employed as a consultant on one of the larger corporate teams, Anthony is now Head of Private Client at SSW. He also heads the European team, assisting companies and individuals on their immigration planning for the post-Brexit world, as well as submitting applications under the current European regulations. In addition to his caseworking responsibilities, Anthony regularly gives presentations on all aspects of UK immigration, as well as the latest updates on immigration policy during the Brexit negotiations. Stephanie and Anthony, thank you so much for joining us today.
Thank you, Eric.
Thank you.
And so quickly, I just want to go over today's agenda. Stephanie and Anthony will be providing a quick Brexit update and then discuss the UK settlement scheme. The format's going to be a little different today. It's going to be more of a roundtable discussion between our two presenters. So anyone listening on the line, we encourage any and all questions. So please ask your questions throughout the presentation, and we'll get to those during the discussion, and then afterward we'll dedicate some minutes to that. So without further ado, I'm going to hand it off to Stephanie and Anthony.
Great. Thanks again, Eric. Hi, Anthony. Thank you so much for joining us again. I know we spoke about the 6-month mark to Brexit, and here we are close to 4 months.
Yes.
So last time we discussed that there was a no deal for Brexit at this time, but it was close. And where would you say we are today?
Probably about the same, really. Edging ever closer, but still no ultimate decision. Where the point that we're at the moment, or so we're being told, is that it's 90% agreed. The sticking point is the Irish border issue, which has been a sticking point for several months now. So we, of course, are not privy to the discussions between the UK government and the EU over that. There is a lot of discussion over the border and how each party wants that to resolve itself, but at the moment there's still no agreement, and so until there's an agreement, there is no deal. But hopefully that will resolve itself shortly.
Great. And so, any thoughts on when it might resolve itself? Any speculation on that, or just wait and see?
If I knew that, I would put money on it. But unfortunately, I think nobody really knows. There are ongoing discussions. I saw in the news at lunchtime that there is actually another conference being held at the moment in Ireland to discuss the Irish border issue between the UK and the Irish authorities, where there are some deputies. Our Prime Minister is currently in Belgium and France in connection with the Remembrance Sunday activities that are taking place over the next few days. So it's her deputies that are currently thrashing out those discussions at the moment. So we could we could have something this afternoon. It's more likely it's going to be in the next few weeks, I would have thought. We keep being told that they're nearly there, so hopefully in the next few weeks we will actually have something, and we will know whether or not it will be a deal or no deal exit.
Okay, great. And there was talk previously when we spoke a couple months ago about a second referendum. Any more talk about that?
More of the same, really. Still a lot of pressure groups that are pushing to hold a second referendum. The reality, though, I think, is that there won't be a second referendum. But there are people who are a lot more better connected than I am that will have better views on this. But certainly, I think it's something that would be nice to have. But I don't think that is really going to happen, simply because the government have time and time again said that there will not be a second referendum. And I would be inclined to believe that as much as some people would want a second referendum to potentially scupper this whole exit or Brexit at the last minute and for us to remain a part of Europe, I think the reality is that there won't be a second referendum, and that as of 11 p.m. on the 29th of March 2019, we will no longer be part of the EU.
Wow. So in summary, really, Brexit, there's still, like you said, no deal. Looks like there will likely not be a second referendum, and so it's just a matter of waiting and seeing what's going to happen.
Absolutely.
So with that being said, let's move on to the EU settlement scheme and what's going to happen to EU nationals that are in the UK. And what the Home Office is proposing at this time. So let's move on to some key dates, like you've just mentioned. So, like you said, 29th March 2019 is a fairly key date. So what happens then?
Okay, so at midnight European time, or 11 p.m. UK time, the UK will leave the European Union. So as of 11:01 or 12:01, we will no longer be a member of the European Union. We will be on our own. That moat between us and Europe will be even bigger than it was before. And as of that point, under the terms of the withdrawal agreement, any existing EU legislation should be written into UK law. Now, as part of that, there is provision for European nationals that are currently living in the UK and those that will be coming to the UK. There is a transitional period in place that has currently been agreed as coming to an end on the 31st of December 2020. So anyone planning to come to the UK will still be able to come to the UK on the 30th of March, for example, and show their passport, and they will be allowed to enter the UK as a European national. That legislation is already being written into the immigration rules. There is a new appendix that has been added, Appendix EU, which covers European nationals and closely mirrors the current European regulations that are in force and govern the movement of the free movement of European nationals to and from the UK. Now, under Appendix EU, as I said, it's a very similar piece of legislation, but it simply writes those rights of EU nationals into British law rather than European law. So, as I said, there is a transitional period. During that transitional period, a number of things will happen, or have to happen, I should say. So, if you are a European national and you are coming to the UK, between the 29th of March 2019 and 31st, well, and sorry, the 30th of June 2021, European nationals will have to make an application for either pre-settled or settled status. That is what is being proposed at the moment, and simply what that means is that the EU national will have to apply for confirmation of their status, so that they can show that they have a right to be in the UK. For those people that have been here for over 5 years, they would qualify for settled status, which is in effect indefinite leave to remain or permanent residence in the UK. For anyone that hasn't been here for the full 5-year period, they will be able to apply for pre-settled status with the view that once they reach 5 years residence in the UK, they will then be able to apply for settled status. Once you have permanent resident status in the UK, it gives you a number of legal rights within the UK, and obviously is another step closer to applying for British citizenship for those individuals that want to apply for citizenship. As I said, the transitional period actually finishes in December 2020, but the Home Office will allow another 6 months for anyone that hasn't yet applied for settled or pre-settled status to apply for that status, so that by the 30th of June 2021, any European national that wants to remain in the UK should have settled or pre-settled status, and that includes any European nationals that already have a status under the European regulations. So if you're a European national and you already hold permanent resident status under the European regulations, but you haven't applied for citizenship, then you will be required to apply for settled status. The exact process of doing that has been widely advised, but I think we're going to talk about that in a little minute. So I don't want to get too far down that road just yet. Following 30th June, as I said, 30th of June 2021, all EU nationals that arrived prior to the 31st of December 2020 should have settled or pre-settled status. But anyone that's arriving on the 1st of January 2021 onwards will be subject to the new immigration requirements, whatever they are, depending on what's agreed with obviously Europe. At the moment, the proposal is that European nationals will be subject to the same visa requirements as any other national. So if you're a US national moving and you've moved to the UK, you should be very familiar with the visa requirements, and that will also apply to French, German, Polish nationals, etc. Unless, of course, an alternative is implemented. So that's really a very sort of brief overview over the timeline between now and June 2021. Obviously, there's a lot of scope for movement within that. All of this is still partly part of the negotiations between the UK and Europe. Some of those dates may change. There's talk that the transitional period will be moved or delayed. There's even talk that there has been some talk that the actual date of the UK leaving the EU may be moved as well, or delayed by a couple of months. Whether that will actually happen or not, we don't know. There's still a lot that's been undecided and is still up for discussion. So this is the timeline as we understand it at the moment. But as always, there may be some flexibility, and some of those dates may slide somewhat.
Great. Well, thank you for that update. I think one of the key points that's noted is that employers will need to ensure that they have an EU compliant workforce at this state. So, what are some of the things that the employers will need to consider as, as all these dates are approaching? I mean, it's hard to believe that time has already passed and we're almost on the eve of Brexit. So this will happen very quickly. So, what are some of the things that employers need to think about during this process?
Well, this is it for a long time. I think since 1973, employers have not had to worry about their EU workforce because since that period, European nationals have been able to turn up for work, present their passport, and be able to work. The problem now is that following the EU, following the UK's exit from the EU, companies will have to carry out right to work checks on their European workforce. Now, there is a lot of confusion at the moment over what the requirements actually are and who's going to be required to carry out checks. But obviously, because it will be a mandatory requirement for European nationals to apply for settled or pre-settled status before the end of 2020, as an employer, you will want to ensure that your workforce has the correct status in the UK. The Home Office are talking about getting the message out to everybody by putting adverts in newspapers, connecting with local representative groups, with embassies, to get the message out to those people. But there will be people that will completely miss all of this, that will just carry on. They know that something's happening, but they don't know what they need to do. And I am absolutely convinced that there will be a large number of people that come December 2020 or June 2021 that will European nationals that will not have made that application for pre-settled or settled status. And if you are an employer and you are employing these individuals, then if you are unfortunately the target of a Home Office audit, or you are an investigation is carried out on your premises and you have this EU undocumented workforce, then that could put you in a very difficult position, in the same way that you would be if you were employing an illegal worker today. So there is a lot of discussion about it. A lot of employers are aware that that Brexit is coming, that their EU workforce will need to do something about their status in the UK, and a lot of employers are getting that message out to their employees, saying, changes are coming. Make sure that you know what's happening, and be aware, be ready to do something once the new settled status and pre-settled status opens to everybody. Now, what we're saying to employers at this stage is that you really need to be thinking about the levels of support that you are going to give to your European workforce, because some companies have a large population of European workers, and already we are seeing companies being approached by their workforce and saying, well, what support are you going to give me to help me with my status post Brexit? If you are employing an Australian national, for example, you would you help them with their visa? And if so, would you help your European workers with their paperwork? Also, there's things to think about, such as budgets. There's so much to think about for employers at this stage, that don't wait, start preparing now, so that once the new settled status comes in, you are ready and you are able to deal with it, because those questions are going to come and you need to be ready for them.
Right. And so to your point then, I mean, so with regard to the EU national population in the UK, it's estimated to be about 3.5 to 3.8 million. So as you said, some will certainly likely slip through the cracks. Can you talk a little bit about the pilot program that the Home Office has implemented and where they're at with that for the settlement status?
Yes. So the idea is that as part of the introduction for the settled and pre-settled status, is that the Home Office are carrying out testing phases. Now, they've already completed the first stage of testing, which involved a number of university students and NHS trusts in the Liverpool area of the country. And we've already had a report back on that, and that involved around 1,000 participants, which, according to all reports, worked very, very well. They were the first people to have access to the new application system. They were able to submit their applications online or use this app that everyone has been talking about. And so that's completed. The reports come out. They've made some suggested amendments, and now they've actually started the second stage of testing, where they're opening up the group of people that can apply from around 4,000 people which was the test group for the original stage, and now it's a much bigger or larger group of people that is going to be able to apply. So that second stage of testing opened on the 1st of November, and that included all the original group of people, so people at the universities and the NHS trusts, and then the next stage, the sort of the big step up, is going to happen on the 15th of November, where it's going to be opened up to people who are employed by a tier 4 registered sponsor. Now, for those of you not familiar with the tier, with the points-based system and the tiers, the tier 4 category is for universities and higher educational organizations who will sponsor their students. So they will so all the universities in the UK, anybody that works for those institutions will be able to apply for settled status or pre-settled status. It will also be open to people in certain disadvantaged groups, for example, children that are being looked after by certain local authorities, but also other groups such as victims of domestic violence, people who are in disadvantaged groups. So that is going to be a real increase in the number of people eligible to apply under the new settled or pre-settled status. And then finally, the last group from the 29th of November will be anyone employed by any NHS group within England and within the UK. So anyone England, Wales, Scotland, or Northern Ireland that's employed within the NHS or medical groups will be able to apply. So that is a large number. So if that goes well, then potentially we could be looking at even wider group, set of applicants for sort of January, February time potentially. This is all of course subject to the testing going well. The reports we've heard so far are that testing is going very well, so hopefully, fingers crossed, it may well be the case that applications for settled status and pre-settled status will open to the general public before that March cut-off. I think that is the Home Office's intention, is that they would like this to be open before March so that they can get a head start on the sheer number of people, the 3.5 million EU nationals and their families that are in the UK that will have to submit all their applications before the cut-off in June 2021. So that the testing phase is going well at the moment, so hopefully it will continue to do well. We're looking forward to submitting our first, assisting our first clients with submitting their applications in a few weeks. So hopefully that will all go well, and we'll have a better idea of how it's going to be come launch day.
That's great. So how does, there's certainly some complexities involved with exactly who needs to register. So we're going to go through some scenarios because that show a bit of the nuances with who might be able to register. So could you talk through this scenario regarding the French nationals here?
Sorry, just one second.
Oh, sure.
To catch up. Oh yeah, so these scenarios we looked at are mainly to do with sort of families and their children, because the rules regarding the status of nationality of children, born in the UK is quite a complex area. So this just we just came up with a few scenarios just to set out some options, some commonly experienced situations. So in this particular case, you've got a French couple that have been resident in the UK for a very, very long time. They would be eligible to apply for settled status because they have been in the UK for more than 5 years. And the question really is talking about the rest of the family. In this case, the child was born in 1999, which is before the rules were changed. And so for children born in the UK prior to October 2000, if either of your parents were exercising treaty rights in the UK, then you would be born British. So in that case, where the parents have not yet applied for any kind of status, they would be required to apply for settled status, but the child wouldn't necessarily be required to do that, although they could do if they wished. They wouldn't be required to because they would actually be considered as having been born British, so that wouldn't be a requirement. So these are just examples of situations. We get a lot of phone calls from people that are worried about their status, about what they need to do now, what they will need to do in the future, and obviously part of our role here is to have those discussions with the people and talk through the options. So we're now finding that whereas this time last year we were having conversations with people and we were advising them to say, well, look, given your circumstances, we would advise you to apply for permanent residence under the current rules. We're now getting to the point where we're saying to people, well, actually, if you wait a few months, then you'll be able to apply for the new settled status. You won't need to make 2 applications. You can just make the 1 application, and that will see you through to whatever you wish to do in the future. Whether you just want to remain in the UK on your settled status, or if you eventually want to apply for citizenship, then you will ultimately have that option as well. So these scenarios are just examples of the sorts of questions that we get on a very regular basis. And obviously, it's quite difficult to give general advice because everyone's situation is unique, and what works for one person might not necessarily work for the next person.
Right. And so we're going to skip to scenario 3, which is again a similar question with regard to child citizenship. So if you could review this and as well, if you would.
Yeah. Again, there are a couple of options here. The difficulty with this scenario is you're trying to cover so much information in one go. So, I mean, you've got somebody here that's German national, has been working in the UK since June 2011, and again has a child born in the UK. Now, there are a number of options available here. You could potentially apply for settled status. In this case, you want to secure British citizenship as soon as possible. So potentially you could register the child as British. Potentially the child could be considered as being born British. If we were able to show that the mother had actually been deemed to have permanent residence before the birth of the child, then we would be able to argue that the child was actually born British. If that's not the case, for example, if there was a break in employment, or there was a period of time that was spent outside of the UK, and it was the case that the child wasn't born British, then we could look to register the child as British on the basis that ultimately the parent would meet that 5-year residence requirement, and then on the basis that the child was born in the UK, that we could register the child as British on the basis that the mother had subsequently become settled in the UK. Of course, you would still then have, if the mother chose not to proceed with British citizenship for the child, then potentially again you'd be looking at being able to apply for settled status. So there's always a number of options for families, particularly those that have been here for longer than 5 years. Different backgrounds in terms of what you've been doing in the UK will lead to different options for you. As always with these, we always advise people that if they've got a particular question about their their options or what they might qualify for, then just get in touch with us, and we'll walk you through it, and we'll have a look and see what we can do, and what you might already have without knowing it. So the thing with European nationals is that there's a lot of automatic status that takes place at the moment, but that will change in the future.
Okay, great. Well, thank you for that. So just moving on, let's go through some options that employers have in terms of their EU population. So, for example, option one, taking no action, right, and just leaving it to the employees. Do you want to talk a bit about that?
Yeah, I mean, we recognise that employers have a number of different options in terms of what they can offer their employees. Now, there will be companies out there that will say, well, look, it's nothing to do with us. This is all down to the employee to resolve their status in the UK. As long as we, as a business, remain compliant, then that's all we need to worry about. So what we've tried to do is we've tried to sort of set out a number of different options and what the pros and cons are of those options. So, for example, option one would be a very cheap option for an employer. There's nothing that you really need to do. There is no legal obligation on the employer to do anything beyond ensuring that your workforce is compliant. So you put all the onus on the employee and hope that they get everything right. Now, of course, this might lead to issues in the future. For example, as I said earlier, if you support non-EU nationals with their visa applications, then you may well start getting questions from your EU workforce saying, well, hang on a minute, if you're giving my American colleague, you're supporting their visa application, why aren't you supporting my settled status application? There was a possibility that the EU worker might apply for put the wrong application in. It shouldn't happen, but it does happen. People regularly put in the wrong application, which then obviously is refused eventually, and that's when they come to us, and then we try to help resolve it. You will almost certainly have a lot of questions and requests for information, and are you going to answer those? Are you just going to say, well, sorry, we don't know the answer, you'll have to find that out for yourself? How do you deal with those queries from your workforce? And of course, there's no tracking. You don't know what of your European population who's applied for the settled status. When it comes to 1st of January 2021, has your workforce got the right to work in the UK? How do you know if you haven't tracked it? How do you know you have a compliant workforce? So
Right.
option one is it is an option, but not one that we would recommend, really. But we can't force people, so.
Right, absolutely. And then what about option two, where there's still no application support, but certainly educating the employees through seminars and surgeries?
Yeah, so we've already been doing that with quite a lot of our clients. Obviously, at this stage, the settled status hasn't opened fully, but we have been going in and explaining to clients and their employees what their options are. And for some people, that's works very well for them. It's very cost effective. At least you can show that you've been giving some support to your employees, and that does usually highlight some of the more complex applications where people perhaps haven't got a straightforward 5 years of working for the same employer. They might have been a student and then had a period of unemployment, then been an employee, and then they brought their spouse over, and their mother-in-law and their sister and uncle, and those will start to come out of the woodwork. But again, from an HR perspective, you've got no tracking of applications. You've given that information out, but you've got no idea what the status of your employees actually is. There's no guarantee of attendance at these seminars. Again, is it fair? Again, people come to you and say, well, look, great, I've learned a lot, but are you now going to support my application? So again, seminars are great. It's a great way of getting out information, but what are you going to do after those seminars? Are you going to support applications, or are you just going to leave your workforce to manage it themselves?
Absolutely. And then option 3 that we have here is, so they have the education, and now there's a tracking provision. What are your thoughts on that?
Yes, so some employers might take this route. For example, HR then, following the seminars and the surgeries, HR set up a system by which they track their EU workforce. Again, you've provided some support. Again, it should highlight some potentially complex applications, but you'll be able to track your applications. The thing with that is, again, you can't guarantee attendance, but from an HR perspective, it suddenly becomes an awful lot of work. You've got to find someone or some people who will then take over that role of tracking your EU workforce. If you're a small company, it might not be a problem. If you're a large company with hundreds of EU nationals, that's going to be a full-time job for someone, because you're going to have to get in touch with all of your EU workforce. You're going to have to say to them, have you been through this? Have you got your settled status? If not, when are you going to get it? You'll need to fill that all out on a spreadsheet. You'll have to keep a track of it. You'll have to chase people. And so that can very quickly become a very, very difficult job. And again, are you going to be supporting? Who's going to be, if you are going to support, who's going to manage the application process? Are you, as the HR professional, going to start assisting your workforce with lodging their applications? How are you going to manage that? So again, a lot of things to think about for that option.
That's great. And then finally, option 4, which is the fully managed Brexit immigration service. So, please enlighten us on this option.
Yeah, so this is something that we've put together to offer to our clients, and obviously anybody that wants to take advantage of it, in that we will actually come in and do the work for you. So obviously we've got a lot of experience of dealing with European nationals and applications, certainly under the old system, and of course under the new system we're fully up to date on what the latest developments are. So what our Brexit immigration service will do is we will actually come in and we will do all that tracking for you. You simply need to tell us who your European population is, and we will provide you with all the support and backup that you need in order to ensure that your workforce is compliant, and that by December 2020 that all of your EU nationals have the correct status. As part of that, we will come in and give surgeries. We will have one-to-one sessions. We will assist the applicants, the individuals and their families with actually submitting the applications to make sure they make the right application at the right time. We will provide a tracking service, so that if you need to know if John Smith has got his settled status, you'll be able to log in and see where what the progress is on his particular application, for example. So and at the end of it, we will then provide you with a report and show you, yes, all of your workforce is compliant, and this is the status that they have. So obviously we're not going to force people to do this, but we develop this in the knowledge that this is a big project for some companies, if not some companies, in fact for all companies. If you employ EU nationals, then you will need to be aware of what the requirements will be for them. So this is something that we've done. Hopefully people will find it helpful, and we've already had some companies that have come in and said, this is absolutely exactly what we want. We don't want to have to deal with our EU population. We just want you to manage it and then report back to us at the end. So hopefully that this will be a solution for people, and we hope that a lot of people will find it useful.
Great. So well, this has been a really great overview of EU nationals, the settlement scheme, and certainly things companies need to think about and steps that they can take. And so with that, are there any questions from the audience? Okay, well,
we'll give it a few seconds. Again, if you want to ask any questions, please do so using the GoToWebinar control panel that you'll see on the right-hand side of your screen. So just type those in, and we'll see them, and we'll try to get to them. So we'll give everyone a few seconds if there are any questions.
Okay. Well, great. Well, Anthony, thank you so much again for your time. I really appreciate, all of the overview about regarding Brexit and the settlement scheme, and again the options that employers can take. And I'm sure we'll be speaking again for another update to Brexit, probably in the new year. So
Fantastic.
thank you again. We really appreciate
No
it.
problem at all. It's been a pleasure.
Great. All right. Thank you everyone for joining us. And again, this recording will be sent out to everyone, so please keep an eye out for that. Thank you. Have a good rest of your day, and I hope everyone has a great weekend.